When can you modify child custody orders due to changed circumstances? Imagine you're trying to plan your child's future, but suddenly life throws a curveball. You might wonder if the current custody plan still works or if it needs to change. Well, that's what we're here to clarify. Child custody orders can be changed when there is a big, unexpected change in circumstances that affects the child's well-being or how a parent can follow the current plan. Courts want to see proof that these changes are serious enough to justify a new arrangement and that the change is best for the child. A key point is that the change must be substantial. This means it has to be more than just small or expected changes. For example, if a parent gets a new job with a different schedule that makes it hard to stick to the current visitation plan, that could be a substantial change. If a parent moves more than 50 miles away for a long time, that also counts. Other examples include health issues that prevent a parent from caring for the child, new medical or school needs, or if a parent is involved in criminal activity or domestic violence. Even if there is a big change, the court will only approve a modification if it is in the child's best interests. This means the court looks at safety, stability, and the child's emotional and physical needs. The child's happiness and security come first. To make a change, a parent must file a formal request with the court that made the original custody order. They need to explain what has changed and why the change is necessary. The other parent will be notified, and both sides can present evidence. Sometimes, the court asks the parents to try mediation first. If they cannot agree, a judge will review everything and decide if the custody order should be changed. Supporting evidence is very important. This can include work schedules, medical reports, school records, or proof that the current visitation schedule is not being followed. Sometimes, professionals like teachers or therapists may be asked to give their opinions. The court may also consider the child's preference, especially if the child is old enough and mature enough to express their wishes. But this is just one factor among many. Remember, custody orders can be changed more than once if new significant changes happen that impact the child's safety and happiness. In short, you can modify child custody orders when a clear, unexpected change occurs that affects the child's life and the current plan no longer works. The change must be supported by evidence and be in the child's best interests. The process involves court approval, and it helps ensure the child's needs stay the priority.